see, he is the buyer under the rep fee for $409,000 in January of 2020. The seller's disclosure statement does state that seller is obligated under law, regardless of occupancy, to disclose to buyers defects in the property and facts known to seller that materially and adversely affect the use and value of the property that cannot be discovered by a reasonable inspection by an ordinary prudent buyer. The seller's disclosure also reflected that in response to the question, quote, have you remodeled, made any room additions, made structural modifications or other alterations or improvements to the property, that the seller's property disclosure states, quote, county approved and licensed contractors given at possession, close quote. This is on section 2A of the seller's property disclosure, again, exhibit 3 to our initial motion. With respect to hazardous conditions, substances, and materials, that would be item 20A in the seller's disclosures. The representation was made that no, there were no such hazardous materials or substances, including asbestos. Then in 4C, the question is asked, quote, has all or any portion of the roof been repaired or replaced during your ownership, close quote. The questions about, quote, aware of any past or present leaks in the roof, close quote. The answer is no. That is on section 4A of the seller's property disclosures. With respect to defects in the roof, structural issues, dry rot, moisture, and or ice damage, that was asked in section 4B of the seller's disclosure. The representation was made no. With respect to past or present accumulation, water leakage, water accumulation or damage in the basement or crawl space on the 19A, the representation was made no such issues. Same thing on 19B with respect to past or present moisture-related damage caused by flooding, moisture seepage, leakage, leaking or broken pipes or plumbing fixtures. And in 19C, the representation was made in response to, quote, the question, quote, any attempts to repair any moisture-related damage and or prevent any recurrence of water and moisture-related problems to the property, close quote. The answer was no. The question was asked in response to, are there any written warranties presently in place for the roof? The representation was made that those would be given at possession. So my clients closed on the property, Judge Mabee, and they took possession in January of 2020 without any of these permits or any other materials being provided. About a year later, problems began to manifest in the residence. First, in January 21, the main water line started leaking from corroded copper piping, flooding the basement and a portion of the front left basement bedroom. In spring of 2001, they noticed water accumulation on both floors of the residence. And in August of 2021, they began to discover mold growing out of the walls in the basement that their minor son used, 10 years old at the time, I believe. Fall of 2021, plaintiffs determined that water was leaking through windows in the basement that had not been properly installed. And in early March of 2022, the drywall in the basement bedroom in which plaintiffs found mold was repaired and replaced. But in the spring and early summer of 2022, they found mold growing again. And they called Precision Home Inspections, mold amelioration specialists, to run tests on the property, which disclosed hazardous levels of mold and mold spores. The plaintiffs also in late August of 2022 retained roofers who advised that the roof of the residence was rotting on the sides, which caused the soffit and fascia to come apart and water to enter the residence through that compromised soffit and fascia. They also discovered not fewer than 3 holes in the roof. Plaintiffs and their 3 children moved out of the property in August 2022. They are still paying a monthly mortgage of $3,100. In addition, they are paying approximately $2,500 a month in rent for another place for their young family to live and be safe. My clients in 2022 began asking defendants to provide these permits and warranties and other materials that they promised would be given at possession, promised under oath in seller's disclosures would be given at possession. They filed this lawsuit in November 2022 because the defendants did not answer them, and they were not getting any resolution. And they asserted causes of action for breach of the contract, that being the REPC, the covenant of good faith and fair dealing applied to it, and fraud. The damages that they allege are basically pervasive damage to the structural components of the residence. That would be the wooden framing, the door frames, the window frames, the flooring, and the drywall. They allege that water accumulation also caused mold and mold spores to pervade the residence, drywall, structural, and other structural components. They allege damages to cure the defects in the residence that defendants misrepresented or concealed in the amount of, in the complaint. They allege damages of $409,000 to cover the possibility of the residence being demolished. But they have also, since the briefing on this motion, obtained the estimate from Samuel Williams that is a cost plus 10% estimate to basically redeem the property, put it into advertised condition. Factoring the cost plus 10% model, that estimate is $446,000. My clients are also suing for costs to replace household articles and personal property destroyed by mold, which damages they allege to be not less than $40,000. They also seek to recover damages that they have paid in rent while not being able to occupy the property. They also allege physical injury as a result of defendants' activities, and the physical injuries are set forth in paragraph 96 of the current complaint of record. Item 5 asks for damages for, quote, costs incurred to have medical professionals diagnose and treat plaintiffs and their minor children for various maladies caused by their protracted exposure to the mold and mold spores in the residence. And in addition, my clients wish to recover their attorney's fees under the REPC. They also now want to rescind the REPC, although we understand we probably would have to file a proposed amended complaint. And actually, I should have said get leave to file, from Your Honor, to file that complaint to address that eventuality. So the case got filed in November of 22. My clients served their initial disclosures, and the defendants served theirs on March 2nd, 2023 through their previous attorneys. They served 179 pages of documents, which including what are exhibits B, D, and J to the defendant's opposition to the plaintiff's instant motion. On March 16th, I served on behalf of defendants their first interrogatories and requests for production to the defendants. On March 23rd, the defendant's initial co-counsel and their firm filed their notice of withdrawal. On August 28th, Austin Nate, Kennedy Nate, and Michael Johnson of Ray Quinney and Nebaker entered their appearance for both defendants. Attorney Austin Nate suggested in an email to me that our clients agree to serve their responses to discovery that we had propounded on May 25th, and I agreed with that. And we had an informal stipulation through email that was not entered on record. On May 8th of 2023, my clients and I learned of some activities involving Kouri Richins and K. Richins Realty individually and collectively that forced us to consider different approaches to this case. how we alleged our claims, how we proved them, or who the defendants might be, and how we might collect it. Plaintiff's instant motion on May 9th. Attendant to that investigation or effort, I learned that the defendant, Kouri Richins, was at that time a defendant in 3 other cases pending in Summit County. The estate case to which Attorney Lazaro referred in our last together, and what I call the prenup case in my client's filings. I also saw a guardianship proceeding that has since been dismissed in deference to a private juvenile proceeding and the juvenile court's proper jurisdiction over that. I noticed that the estate case and the prenup case had been pending since March of 2022, so some 8 months before my clients even filed the instant lawsuit. And I noticed that the Kouri Richins had the same lawyers throughout the case. In other words, from filing forward. I noticed that Austin Nate and Attorney Lazaro entered their appearances in the criminal matter on May 8th, the day it was filed. I reviewed the filings in particularly the prenup case, but also the estate case. I'm familiar with what I have my arms around, I should say, around what is going on in those cases. And in particular, there are 430 filings that have been done in this prenup case. And so I made certain conclusions about counsel and my ability to work with them. I decided that I was best off pursuing this writ of attachment and also filing an ex parte. My clients took the permits that the defendants provided on March 2nd, 2023 to their neighbor, Jake Ivey, who coincidentally is a general contractor. His declaration was filed on May 16th. He notes there was a lot of work done before the permits were provided by Heber City and what they entail, including structural framing, what appeared to him to be a full bathroom and kitchen remodel, and electrical work and plumbing. He saw no permit related to window replacement, and there is no permit related to window replacement unless defendants still have it and are going to provide it later. Mr. Ivey also testified that he's been in the property that my clients own while Val Maynard owned it, the previous owner, and after my clients purchased the property from Kouri Richins Realty. He noticed that walls have been removed, and some of them, to his experience and eye, seem to be load-bearing walls. And he notes that he also saw beams that had been installed that he had not seen when Mr. Maynard owned the residence. And he notes that removing walls and such generally requires an engineering stamp. On May 19th, 2023, Kouri Richins filed a motion for general stay in both the estate case and the prenup case. I got some correspondence from Attorney Nate about extending our client's discovery responses, and we did not agree to do that. And at 8:09 a.m. on May 25th, I filed a certificate of service for my client's responses to discovery. Attorney Nate, or I should say defendants through Attorney Nate, filed their motion to stay in this case on April 25th, so nearly a week after they filed the virtually identical motion in the other cases. And so I deduced from this that all I'm going to get from defendants is stay, right? And that I have to stay, and my clients have to stay, and we all have to stay while their stay is pending. Their motion for stay, I should say, to have it granted is pending. Judge, we also procured the declaration of Val Maynard. That's docket 40. That was filed on June 5th. Mr. Maynard testifies that in 2019 he wanted to sell the property. There were a number of conditions that he did not want to repair before selling it, and wanted to sell the property and the residence as is. Kouri Richins contacted him and told him she worked with an investor that bought homes and that they fixed up for resale. A few days later, she and a man that she introduced as a crew foreman came to inspect the property. They toured it. They went through every room and the backyard. The crew foreman, or the man who accompanied Kouri Richins, took photos of every room in the residence and the closets and whatnot. And he disclosed, Mr. Maynard, to Kouri Richins and the man accompanying her, that the downstairs bathroom was not being used due to water damage. And again, this is back in summer of 2019. The wallboard and the floor molding had disintegrated from water damage along the bottom of the walls, and Mr. Maynard disclosed that the bathroom needed a complete redo. He disclosed that the external faucet in the backyard was not sealed, which had caused water to back up and come into the residence. And they looked at the roof.
Mr. Otto, sorry,
yes.
I'm going to stop you there because I did go back and take a pretty close look at the declaration of Mr. Maynard after
Yes.
I reviewed the opposition that was filed. When you say he disclosed it wasn't sealed, I mean, I'm not certain that, well, let me just state it this way. I think Mr. Maynard's statements in his declaration were somewhat vague in terms of spray back. I mean, I couldn't understand for sure what he was saying there in terms of, you know, if there was a leak in that faucet and it was spraying directly at the house, which caused it to leak. When you say it wasn't properly sealed, I don't think he says that. So how do you reach that conclusion?
It's all right. It's to me, the larger question is, did he disclose, notwithstanding